So the law right now has a bunch of things in it where it relies on jury sequestration. It relies on it. And I always say there's no more such thing as jury sequestration. You have a phone, you walk into, if the OJ trial was happening in 2025, not 1994, 1995, when you walk into the jury selection process with your phone's going to recognize that you're there for the OJ case, and it's going to start feeding you cases about the OJ case. Your opinion will be colored about that case before you are even selected as a juror, right? So the jury case, the OJ case is everything in our society. When I was in law school, all we talked about was the OJ case back in 2003, 2000, it was fresh after the OJ case. And we would talk about the OJ case, and the law is still catching up, right? Jury sequestration is still catching up. Jury ideology is catching up. This was the case of the jury. The jury controlled this case. That was everything. So I cannot understate the importance of that case. And one more thing you said earlier that I agree with. I use a phrase, I say Furman-esque, right? So like with Michael Proctor, I say his conduct, for example, was Furman-esque. There's several investigators because things catch up to you, right? You were trained during the OJ era, and you are still an investigator. You know, you're gonna think that you have covered everything about the OJ case is everything about our profession. Maybe 200 years from now, it will just be a historical thing that would not be relevant, but it is so relevant to this day to every single criminal case, even civil cases.
Yeah. And again, it's Sunday, and now you talk about a juror. We have a juror, Lon Cryer. His insight is brilliant. It's how his thought process went through all of the different, from Furman to the DNA evidence to the glove to all of it, and then deliberations. Oh my gosh, great backstories. Yeah, I think 4 hours after 9 months of basically serving a 9-month sentence with these strangers they didn't know.